That is to the rare case right now. But I submitted before your lordship that the petitioner are the husband, and the second petitioner is the father-in-law, and the third petitioner is the mother-in-law. And the private respondent number 2 is the wife, aggrieved party. And the marriage solemnized between the parties in the year 2015. And the case started, this case under section 12 of the Domestic Violence Act was filed in the year 2022. Now I am just on the basis of the fourfold aspect, because so far the case is concerned, the mother-in-law and father-in-law would not be a party in the instant proceeding. This is the first thing. And the second thing, the entire incident took place at Modhongram within the jurisdiction of the North 24 Parganas, but the matter was filed before the learned SCGM Alipur. So this is 27 of the PWD Act is bar over the matter relating to the jurisdiction. Now the third thing, that the matter was filed, the date of incident mentioned by the aggrieved party in the petition that in the year 2017. But there is a dictum of the Honorable Court, and so many judgment of the apex court is there. They must be filed within a year. The matter within a year, the matter must be filed from the date of incident. The first date of incident mentioned in the petition in the year 2017, and this matter was filed in the year 2022. So it is not within the time of the 1 year. The matter was not filed. So bar by limitation. So first jurisdiction, then this bar by limitation, and third thing, that the without giving the report by the service provider under section 13 of the PWDB Act, learned magistrate without considering the report, without asking report from the service provider, learned magistrate took cognizance of the matter. So these are the things. And the fourth thing, so for the definition section 2F of the Domestic Violence Act is concerned, that the domestic relationship and share household, the father-in-law and mother-in-law will not come within the definition section of 2F of the Domestic Violence Act. Now, my lord, kindly come to the proceeding. And the fact remains here once again that the lady, that is the aggrieved party, suppressing the first marriage, married the petitioner, first petitioner, and during the pendency of the first marriage, divorce application before the learned judge at Alipur, during the pendency, not cleared the divorce, not getting the decree of divorce, suppressing the material fact, he married once again the petition number 1. And over the said matter, we made an application FIR against the lady under section 420, 406 in the year 2017. Subsequently, we made an application against this lady in the another application under section 494 in the year 2018. And thirdly, we made an application under section for custody of the child, because one child is there in the year 2019. So after,
whose child?
Out of wedlock, one child.
Which wedlock?
This petitioner along with the aggrieved party. Now that matter is pending. The husband has filed this proceeding, all the proceedings in the year 17, 18, 19. And subsequently after that, this is the counter blast. This domestic violence had been filed in the year 2022. Now kindly come to the petition.
So how come that you continue with the marriage, you give birth to a child, and after a passage of so many years, you file again, I mean, as you said,
My lord,
complaint?
There is a long history about the matter.
So
There is a long history. Just kindly come to the petition under section 12 of the domestic violence. Kindly come.
Which page?
My lord, this is certified copy after annexure. Last part of my application. Last part of my application, it is a certified copy. In the Court of Learned Additional CGM at Alipur, starting complaint case number. Last part of my application, just annexure the complaint petition under section 12.
Complaint case?
Yes, complaint case 12. An application under section 12 of the Protection of Women from Domestic Violence Act 2005, praying for order / relief under section 18, 19, 20, and 22, along with the prayer for interim order under
So what
section.
happened to this?
Got it, my lord?
Yes.
Now, my lord, now kindly come to the contents of the petition. Just in paragraph number 3 of the complaint of the petition, paragraph 3.
Of this petition?
Yes, this petition. Paragraph 3. 3 has got so many A, B, C, everything is there.
Yes. So which one you want to show?
In paragraph 3, this lady did not mention the date of marriage. Very unfortunate. Kindly says the complaint aggrieved petitioner is legally married wife. That the respondent opposite party number 1 is the husband. The respondent opposite party number 2 is the mother-in-law. And respondent opposite number 3 is the father-in-law, complaint such and such. So the date of marriage is suppressing because of the fact that the marriage he was married earlier, suppressing the material fact. Now he disclosed the marriage, date of marriage, kindly come. In 3 of D, 3 of D, that accordingly a divorce suit on mutual consent was filed before the learned district judge at Alipur by the complainant and said Obijit Borua, that is the earlier husband, Obijit Borua. And they obtained a decree on March 2017. But the marriage solemnized between the parties in the year 15. We got the documents. So prior to the earlier marriage, pending the divorce application, suppressing the material fact, once again married the petitioner number 1, Ochut Bhadra. This is the one suppression. Now, my lord, kindly come to the cognizance order taken by the learned magistrate. Prior to that, just before the petition of complaint, prior to that, just 3-4 pages before that, order dated 11/10/2022.
Yes.
Well, got it.
Hmm.
So an application is filed under section 12 of the PWDB Act. Heard learned advocate for the petitioner peruse the application of petitioner which is supported by affidavit, considered, registered the same. Let the case be transferred to the learned GM judicial magistrate at
Okay.
Alipur.
Then thereafter what happened?
So this cognizance was taken without calling any report from the service providers. It is necessary under section 13 of the PWDB Act. So without complying the provision under section 13, so these things has been happened. So this cognizance order is absolutely bad in law. Now kindly come to the subsequent order. We appeared. Subsequently, we got the summons from the learned court and we appeared. It comes from the subsequent order dated 12/12/2022, 22/2/23. Kindly come, we appeared. Now, my lord, one thing, the sees the petition of complaint section para 3:1, date of first incident. Why I'm saying because it should be filed within a year from the date of incident. So as per petition of complaint, it is date of incidence is 17 and the matter was filed in the year 2022 after a lapse of 5 years. So it is barred by limitation also. Kindly come. 3:1. Para 3:1.
So you take all these points before the trial court.
Now, kindly appreciate one thing. Kindly appreciate one thing. We are just so for the father-in-law and mother-in-law, and so for the incident, so for the section 12 is concerned. Kindly appreciate one thing. Kindly allow me to submit because we are concerned because the father-in-law and mother-in-law is it about 70, 72 years and not in a position to appear from Modhongram to Alipur because learned court below is just dictum, not necessary to appear, but finding in the observation that should be appeared before this court.
Okay.
Now,
Yes.
now we are just concerned, kindly sees the decision of the Supreme Court that the father-in-law and mother-in-law, they will not be a party in the instant proceeding. Just I'm reading out the relevant portion. In the result, the criminal petition in respect of the first petition, that is the husband. What should I submit? First petition is dismissed, and the criminal petition in respect of the 2 to 11, that the inmates of the matrimonial home, that is father-in-law, mother-in-law, brother-in-law, everybody. 2 to 11 is allowed by quashing the proceeding against them in domestic violence and DV Acts, such and such. This is the observation of the one of the Honorable High Court.
That is the observation, not the dictum.
Dictum, yes, sorry, dictum. Now the second thing, sorry.
Okay, sir.
So only my prayers, let the petition number 2 and 3, mother-in-law, they should be exempted from the appearance from the court below, and only stay in the respect of the 2 and 3. An entire incident took place at Muddumgram within the district of North 24.
The learned advocate for the petitioner submitted that the application filed under Section 12 of the PWDV Act 2005 by the victim wife had been malicious, suppressing her earlier marriage, the opposite party, the wife is opposite party.
Yes,
two.
Opposite
Number
number
2 had filed the application being 12/12/2022 in the court of learned SCJM Alipur in Turelia, accusing the present petitioners under the Domestic Violence Act. The learned advocate representing the petitioners referred to paragraph 3 of the said application, emphasizing the fact that the child was born to the petitioner number 1 and the de facto complainant in the month of March 2017, and a divorce and a decree of divorce on mutual consent was obtained from the earlier husband of the victim in this month of May 2017. The said application was filed beyond limitation, and a complaint case was filed against the victim de facto complainant, and the instant application under the Domestic Violence Act had been a counterblast to the same. The allegations and counter allegations are to be taken into consideration by the learned trial court at the time of trial. However, considering the age of the petitioner number 2 and 3,
2 and 3, father-in-law,
3 and
mother-in-law,
3, the learned trial court is to exempt their personal appearance on condition to be represented by your learned advocate on each and every date of hearing, and if required, to be present online, failing which necessary orders can be passed by the learned advocate, learned
matter will appear.
trial court. You go before the trial court.
Hello?
You go before the trial court. I'll
But
dispose
this is
of.
the fit case for stay for all further proceeding in respect of all the persons. But I am just asking
Notice
for
to be
only 2 and
issued
3. Only for
upon
short stay
the-
on 2 and 3. Because the next date is coming month, very soon.
State along with a copy of the revisional application and annex documents. এটা দিয়ে দাও. Next date we fixed on 29th of November. Next.